Hey everybody, it's Christopher Small with CMS Law Firm. We do estate planning, we do probate, we do it well. Today I want to talk to you about what ancillary probate is and how you can try to avoid it. Before we get to that though, as always, if you want to talk about more, if you have questions, if you want to just talk, then you can go to estatemeeting.com. You can set up a time to talk with us over the phone or in person for free, estatemeeting.com. Okay, as always, today's question comes from a potential client, now client, that I was talking to this morning. And I've actually had a couple of these come up, so it is sort of apropos to discuss, because if one person usually has a problem, then many people probably or typically have this problem. Not probably, problem. Anywho, so what happened was this person had a loved one pass away. Oh, so first of all, what is ancillary probate? Oh, I'm going to tell you. This loved one had a this person, had a loved one that passed away, and they had property. They lived in Washington, and they had property in another state. Let's call it Georgia. It wasn't really Georgia, but we're going to use Georgia for today's video. Had a property in Georgia, and had some other things that needed to be transferred from one person to another, which is what probate is for the most part, right? Probate is essentially the process of getting the authority and then actually doing the transfer of one person's property to someone else. And because there was this property in Georgia, this real estate in Georgia that was owned by this person, what in fact has to happen is you have to open up a probate in Washington, because that's where the person lived, and that's where sort of everything starts and begins. And then you have to open up a second probate in Georgia to have the authority to transfer the title of that property in Georgia to the right people. Okay, Georgia property, Georgia law, Georgia court, Georgia probate. That secondary probate, that Georgia probate, is referred to in the biz as an ancillary probate. Now you know, okay? Most of the time, we don't want to do one probate, much less two probates. Imagine if someone had property in a couple of different states. You could be doing many different probates. We want to avoid that. And there are a couple of different ways you can do that. The first way is maybe the simpler route. Maybe they're both actually relatively straightforward. But the first is by doing what's called transfer on death deeds for all of the real estate that you own. Basically what you say is, when I die, I want this property to go to this person. It's recorded with the county where the real estate is at, and upon the death of that person, you simply record that death certificate, and the property passes over to whoever was named in that instrument. The problem, however, is that not every state recognizes or has created the ability to record transfer on death deeds. You just can't do that in every single state. I don't know what states you can and can't do it. You can do it in Washington state. I do know that. I don't really know much about any other states, and I'm not going to talk about them because I'm not licensed there. So you can probably Google it relatively easily, to be honest, if you're curious. But that is probably the first easiest way to avoid an ancillary probate. Now, if you have business interests or other things that are located in other states, transfer on death deeds is probably not going to work. So you may want to opt for the second option, which is a revocable living trust. All right. And what's cool about a revocable living trust is you have a box, which is the trust, and you can put whatever you want inside the box. This would include your Washington property. This would include your Georgia property. This would include your whatever other property that you have. You title them all in the name of the trust. And then what happens is when the person dies, there's no need for probate, because technically there's no transfer in ownership. The trust held the property before death. The trust continues to hold the property post-death, and then the trustee steps in to manage the assets inside of the trust, and just follows the rules. So if you, for example, wanted your Georgia property to go to Fred and your Washington property to go to Sally, then the trustee would simply make those transfers, and there's no need for probate in Washington. There's no need for probate in Georgia. There's no need for ancillary probates of any kind. Make sense? Good. By the way, you popped up referral. I'm sorry. I will have one for you soon. I've not forgotten about you. Thank you for reminding me. I can't remember your name, and you're off my screen. Sorry. But anyway, back to the matter at hand. That's what ancillary probate is. Those are a couple ways to avoid it. Hopefully that helps you out. If you have property in other states, then you're definitely going to want to consider one of those two avenues. Otherwise, it just becomes a pretty big pain in the butt pretty fast. You have to talk to multiple attorneys. Who wants to do that? And you have to hire multiple attorneys. Who wants to do that? And this trust can really help you solve a bunch of your problems. Okay, that is it. Thank you for your time. If you like this video, please hit the like button. If you have a question or comment, please leave it. If you know someone that needs to hear this, please share it with them. And if you have more questions or need more help or anything, you can always get in touch with us by going to estatemeeting.com. You can set up a time to talk with us over the phone or in person for free, estatemeeting.com. All right, that's it. As always, thank you so much for your time. I will be here again probably tomorrow to talk to you again. Until that time, see ya.